So I guess we could begin. Welcome to tonight's tutorial on jurisdiction. And I'm happy that we've at least got 3 students here. So thank you, Megan. Thank you, Yomi. And who's the third one here? Hang on. I'm missing the names. Peter. Okay, thank you. So tonight we're talking about jurisdiction. And jurisdiction is crucial because oftentimes the question is raised when whether or not a particular state may have the power either to pass laws or to seek to enforce laws or even to try a person for the violation of certain laws, and whether or not in that case a state may have the power, what is known as jurisdiction, over certain persons, especially if that person does not live within that state, and especially if that person may not be a national of that specific state. So one of the questions we will be tackling tonight, for example, would be, let's assume that there would be hackers, say, based in I don't know, China, or maybe in Russia, and they are very much against certain policies of the Australian government. And as a way of trying to interfere or make life difficult for Australians, they attempted to deface the websites of Australian businesses that are operating outside of Australia. So the question in that particular case would be, assuming that one of those hackers was eventually identified by Australian officers and that hacker happened to visit Australia, could that hacker be arrested on the basis of a law that would seek to penalize actions or behavior, even though they were committed outside of Australia by non-nationals of Australia? So that's one of the questions we will examine when we talk about jurisdiction. We will also try to examine what if there is an Australian citizen who went, say, to the Philippines or to Thailand and engaged in sex with somebody who's only 12 years old, assuming that in these countries it is legal to have sex with underage individual or with children. And yet the question would then be, would it be within the power of Australia to criminalize such a behavior so that a person, an Australian citizen, would then be committing a violation of Australian laws, even if the act was committed outside of Australia and those acts happen to be legal and lawful in the place where they were committed? So these are some of the questions we will be examining when we look at the topic of jurisdiction. And so in terms of the key outcomes after studying this topic, you should be able to discuss and explain the meaning and nature of jurisdiction and the principles on which jurisdiction is based. Now, before we begin to discuss tonight's topic, I wonder if any of you might have questions or any comment before we proceed with tonight's tutorial. None? Okay. So let's begin by looking at the first discussion question. So discussion question 1. John Blast, a former citizen of Ontario and who has a proclivity for underage girls, decided to migrate and live in the state of Lonario, where underage sex as part of its religious traditions is legal. While in Lonario, Blast lived with Chelsea, a 14-year-old Lunarian girl. On Blast's home visit to Ontario, he was arrested and charged with Ontario's laws which prohibit sex in Ontario or abroad with underage persons. He sought the dismissal of the charges against him on 3 grounds. 1, Ontario's laws has no extraterritorial application and cannot be applied to his actions done in Lonario. 2, he cannot be held criminally liable by Ontario for acts that are legal in Lonario. And 3, he is no longer a citizen of Ontario and therefore is not subject to its laws. And so remember, the return of John Blast to Ontario happens to just be incidental. He's just there to visit somebody. Advise Blast. So there are only three of you. Can I ask Megan, Peter, Yomi to try to provide advice to Blast? What do you think? What will you tell him?
I'll have a crack at it, Manjo.
Yes.
So for a start, unless he's actually properly renounced his citizenship and become a citizen of the other place, then he is indeed still a citizen of Ontario. He can't just renounce it to get out of trouble.
Okay.
Secondly, he sought the dismissal of the charges, has no extraterritorial application. So I think it's under the Nationality Principle. They may exercise jurisdiction over their nationals even if they are in another state.
Mm-hmm.
If they were still in that state, then they can ask that state to detain the person.
Mm-hmm.
I was interested to read that they can't actually arrest the person if they went there to arrest them.
Mm-hmm.
I guess because they don't have police powers in those states.
Mm-hmm.
And in some places where there are extradition treaties in place, they can get them extradited to get them out and back to their own country.
Mm-hmm.
What else?
So there is a claim that he cannot be held criminally liable because by Ontario, because the acts he committed in Lunario are legal in Lunario.
Yeah, I remember reading somewhere that so the territoriality is about states having full jurisdiction over all who are within it. So he's not within it. A state may not be subject to the jurisdiction of another state. The nationality thing, I think it comes under the nationality principle. That if it is legal in this state, they can charge people with it if they're in another state.
So in relation to the second ground that Blast wishes to use in order to have the charges against him dismissed, what can you say about that? Would that ground likely be upheld by a court? Blast is saying that he cannot be held criminally liable by Ontario for acts that are legal in Lunario.
Well, I think he can be held criminally liable by Ontario because he's a citizen of Ontario and he still is under their laws.
How about the fact that what he did in Lunario is actually legal?
Yeah, well, he can't be held criminally liable in Lunario.
But he could be held criminally liable by Ontario.
Yeah, I think so.
That's right. Okay, so thank you, Megan. That is the correct answer there.
Not good.
Peter, Yomi, would you want to add something? Peter, Yomi, do you want to say something? Yeah, put it this way, it's always a good opportunity to be able to participate in a tutorial because you want to be lawyers. You want to train yourself in public speaking because if you're going to become an advocate, you appear in court, obviously. You need to be able to express yourself quite well and be able to make statements in behalf of your client. And so therefore, these tutorials give you an opportunity to practice the art of advocacy, not only in terms of the written word, but in terms of oral advocacy. So I wonder if Peter or Yomi may want to say something. No? I mean, I'm not going to force anyone, but I'm just thinking if you wanted to. Perhaps not at this time. Okay, that's fine.
Megan is spot on with her answer that in the case of Blas, nationality principle will apply to him, and he cannot get out of it by renouncing his nationality, even though the law is legal where he resides. He's still a national of. Is illegal from the country of his origin. So yeah.
That's right. So in this case, as correctly pointed out by Megan as well as by Yomi, the grounds for dismissal that Blast alleges or raises are unlikely to be upheld by the courts. So because of the principle of nationality, it is within the power of Ontario to make its laws applicable to its citizens and nationals, even though they may live abroad or commit those acts abroad. That's according to the nationality principle. In relation to the second point, even if it might be legal in Lunario, it is still within the power of Ontario on the basis of the principle of territoriality to determine what is legal or what is illegal according to its own laws. So notwithstanding the fact that the acts committed by Blast may be legal in Lunario, if it is illegal in Ontario, then those acts are illegal. And as correctly pointed out by Megan as well, it is not for Blast to just simply renounce his citizenship. The renunciation would still be subject to the laws of Ontario. Thank you. And so we have Michelle as well joining us. Thank you, Michelle. So there are now 5 of us, which is good. Now, before we leave this topic or this question, let me just change the facts a bit. Let's assume that the law of Lunario stated, Ontario rather, so let's assume that the state of Ontario passed a law that says that it would be criminal for anyone to engage in sex with somebody who is below the age of 14 or 14, who is 14 years old and below, regardless of whether or not that person is a national of Ontario, so even if that person is a foreigner, and regardless if whether or not if that action occurred outside of Ontario. So we're changing the facts a bit, just to push this point. So now, the law of Ontario is such that it is illegal for anyone, including non-nationals, to commit sex with an underage person, even abroad. And let's assume that there is a gentleman by the name of Ibrahim, who is, say, a citizen of, let's say, Syria. And in Syria, let's assume that he has married somebody who is 12 years old. And in Syria, those marriages are legal. And Ibrahim decided to come to Australia to visit, rather to Ontario, to visit Ontario with his 12-year-old wife. They did not engage in sex in Ontario, though. They just happened to have visited Ontario. Now, let's assume that Ibrahim, in that case, who is a citizen of Syria, is arrested by officers of the state of Ontario. Do you suppose that Ibrahim would have valid grounds to question the jurisdiction of Ontario over him for his engagement in sex with an underage person in Syria? And because, as we know, in the facts we gave, Ibrahim is not even a citizen of Ontario. If you were the lawyer of Ibrahim, what would you advise him? So remember, we've changed the facts. Comments from anyone? What do you think?
Well, no, I don't think they could charge him. Sorry, that the story got a bit tangled there in the end. I can't remember the names of the states in that now.
Yeah, so the name of the person is Ibrahim, who is a citizen of Syria.
Okay.
So Ibrahim was arrested when he visited Ontario for violating the acts of Ontario, a law of Ontario, which penalizes sex with underage girls, even if the act is committed abroad, even if the act is committed by a non-national. So the question is, would the state of Ontario have jurisdiction over Ibrahim so that Ibrahim can be held criminally liable for the laws of Ontario in that regard?
So it might come under the protective principle.
Mm-hmm.
So my notes say, provided the crime is legally recognised in states that have a reasonably developed legal system, then a state can assert jurisdiction over a foreign national who commits a crime in another state if the acts may harm them.
Mm-hmm.
It could come under that.
Okay.
I don't know. So how would the acts harm them as a state?
That's right.
I guess it harms them as a state just if it's breaching their own legal system. You know, you can't have one thing that's good for one and not good for another.
That's right. Okay. What do the others think?
I haven't read anything about it and I have no notes about what the law says on the topic. But I don't think there's jurisdiction because there's no actual sex occurred in that jurisdiction. So I think if there was, then I think it might be caught by the law. But I feel like if there's no act in that jurisdiction, then the foreign national aspect can't be picked up.
So that would be the correct answer, Michelle. So Michelle's answer would actually be the correct one. Obviously, the nationality principle cannot apply because these are not nationals of Ontario in the example we gave. The territoriality principle will not apply because the acts did not happen in Ontario. Now, Megan pointed to what is known as the protective principle. Can that principle apply so that it applies even to non-nationals for acts that are committed abroad? For those who might remember what the protective principle is all about. Can the protective principle be raised in order to assert that Ontario can, in fact, exercise jurisdiction for the acts of a non-national that were committed abroad? Can the protective principle be applied? The answer is actually no. Who was that?
Yeah, it's Yomi.
Yes, Yomi.
I don't think the protective principle can apply because it's not try to state security as identified in United States and ZEHI.
Yes. Yes.
Yeah.
Right. So what we need to know is that the territoriality principle, as well as the nationality principle, and we will have a chance to talk about the universality principle as well. These three principles that I've talked about, nationality principle, territoriality principle, and universality principle, they are well accepted principles in international law. But the protective principle, as well as the passive personality principle, are principles that are actually not well accepted, because if you examine the notion of protective principle, it allows a state to assert extraterritorial jurisdiction. So it allows a state to be able to impose its laws on other states, which in a sense, therefore, interferes and violates what is known as the territorial sovereignty of another state. And the extraterritorial application of laws of a state are not well accepted because of the violation of a customary norm of international law concerning territorial sovereignty. And so it is only in very limited circumstances that the protective principle can be asserted, and that is when it is claimed that the actions by a non-national abroad affects the security or the operations of a government of a state. So it is only in those instances. Otherwise, a foreign state would certainly dispute the assertion of jurisdiction by a state for actions committed by a non-national abroad. Involves underage sex. It's difficult how it can be argued that that would impair or interfere with the operations of a government of a state. Okay, so questions before we move on?
So just to clarify,
yes, Michelle.
Is what you're saying there is that territorial sovereignty is considered more supreme than the protection of individual citizens. Would that sum it up?
Then the protection...
As far as the protection principle goes. So if it violates state sovereignty, then it's a no-go.
Okay, let's begin by talking about what the protective principle is as opposed to the passive personality principle. So the protective principle does not relate to really protecting the citizens or nationals of a state. It relates to protecting the security and the operations of a government of a state. So that's what the protective principle is all about. Now there is the application of the principle is disputed. It is controversial because the extraterritorial application of a state's laws, in other words, the extraterritorial jurisdiction that a state may seek to exercise, would actually infringe upon the territorial sovereignty of another state. And territorial sovereignty is a customary norm of international law. It is a customary international law that is well accepted, universally accepted, in fact. Now, there is a principle that is related to the protective principle, and in a sense, the attempt is to protect the nationals of a state, and that is under the passive personality principle. And the passive personality principle states that a state may have jurisdiction over the actions of a non-national, even if those actions occur abroad, if they tend to harm the nationals of a state. So say, let's say Australia may pass a law which would penalize the actions of a foreigner who commits an act against an Australian abroad. In that case, that law would seek to protect an Australian national or an Australian citizen, even if the act would be committed outside of Australia by a non-Australian. So that is what is known as the passive personality principle. But again, even the application of that principle is controversial, mainly again because it is an attempt of a state to assert extraterritorial jurisdiction or the application of its laws outside of its own state. But it has been applied in the United States, as well as in some other countries. Okay. So let's go to discussion question 2. Now, Jacques, is that the correct way to pronounce it? If it's Jacques, if it's French. So Jacques Smith, a Lunarian computer hacker, is part of an international group of hackers who are against certain policies of the Antoine government. On various dates in 2016, Smiths hacked and defaced the websites of Ontarioan businesses operating overseas or outside of the state of Ontario. So the actions of Smiths happened outside of Ontario, but they affected Ontarian businesses operating overseas or outside of the state of Ontario. Unbeknownst to him, the state of Ontario was able to track and identify him as the hacker of the websites. When Smiths went to Ontario to attend a conference, he was arrested by Ontarian police and charged with violation of its laws against hacking. He sought the dismissal of the charges against him. What are Smith's possible grounds for dismissal? And advise Smiths as to whether the charges are likely to be dismissed on the basis of the grounds for dismissal that he is asserting. Can I have a volunteer? What do you think?
So he's a non-citizen.
Yes.
And the act happens outside of the jurisdiction.
Yes.
But the act affects nationals.
Yes.
So it's similar to what you're saying, that there's law that's been passed in America, but the opposite. So I suspect not, because you can't just turn laws on their heads and hope that they work. But I don't know what the nature of your question is.
So there is a law, given that in the example that we gave, there is a law that was passed by Ontario, which prohibits the hacking of websites, even of Ontarian businesses, which are operating overseas. So that is the law. Is Ontario, with the state of Ontario, have the power to exercise jurisdiction over acts of hacking committed abroad by non-nationals against what might be considered to be nationals of the state of Ontario.
Can I give it a go?
Yes, Yomi, yes.
It looks like the protective principle will apply here. Because it's a crime against the state, as in against the rule of law in that state, and the defacing of the website has been prohibited, and it's actually harmed the business of that state, which means it will affect the income, and everything, as in the money that comes into Ontario. So it harmed the state of Ontario. And as in the United States and ZIHI, the judge actually says that if there is the law that's applied and is established in that state, it can still apply to non-foreigner in that particular state, which applies to Jacques.
Comments from others?
Yeah, I tend to agree. I think they could charge him just because they have full jurisdiction over anyone who's within their territory. And once he stepped in there, they didn't have to worry about extraditing him or anything like that. He'd walked on in.
Yeah, but what if the state of Lunario disputes the assertion of jurisdiction? So assuming that the state of Lunario, in trying to protect Smiths, goes to the International Court of Justice claiming that the attempt on the part of Ontario to exercise jurisdiction over a Lunarian citizen is in violation of international law. How would you respond to that? Because in this case, the state of Lunario can claim that the state of Ontario cannot exercise jurisdiction because Smiths, who is a citizen of Lunario and therefore not a citizen or national of Ontario, committed acts outside of Ontario He is not a national of Ontario, and it's possible that, yes, the actions were indeed against certain businesses that belong to, that are nationals of Ontario, but that is not enough to provide jurisdictional basis. What will you say to that?
I think the cyber aspect makes it more difficult, because what's jurisdiction when it comes to the internet? Like, so you suddenly don't have the territorial aspects that you did before.
Yeah, there is. So I'm going to move away from this question a bit, and we're going to go back to that because you've cited that case, Michelle. So there is a case involving Yahoo where they permitted the sale of certain memorabilia that were pro-Nazi and which were very anti-Semitic. So in other words, memorabilia that constituted attacks, for example, against Semites, meaning people of Jewish origin, if I correctly describe it that way. Now, there is a law in the United States which prohibits the anti-Semitism, okay, which prohibits actions that tend to offend the feelings of Jews. So there's an anti-Semitic law in the United States. Now, what had happened was that Yahoo, in an action against Yahoo France and Yahoo United States, the claim against Yahoo France and Yahoo United States was based on the fact that they had permitted the sale of memorabilia through their website, and the sale was meant to occur in France. So it was outside of the United States. Okay, did you get that? Based on a law in the United States. So that was an example of an internet case. How do you suppose the US court resolved that action against Yahoo US and Yahoo France? Because remember, in these particular circumstances, it involved the sale of memorabilia in France that tended to offend the feelings of Jews in the United States, and that was based on laws of the United States. How do you suppose, in an action against Yahoo US and Yahoo France, how do you suppose would a US court rule on that action filed in the US against Yahoo France and Yahoo US? And that is an internet case.
My gut feeling is that in France, you should be able to post whatever is acceptable in France. Mm-hmm. But I suspect a US court probably felt that it was a US world issue and found in that favor. So I'm guessing it went towards the US side.
Okay. And others, comments?
I can't recall what the case is, and I can't really link it to what we're saying at the moment, but there was the case about the plane that went down. Mm-hmm. Lockerbie. Yeah. Yeah. And, you know, pretty much everybody from every nation that had anything to do with it, you know, the airspace that it was in, where it crashed, who it crashed on, who was in it, who was flying it, you know, every nation that had a national involved, you know, had some sort of right over an element of the case in the end.
Yeah. Okay. Thank you. Thank you for that, Megan. And so, as correctly pointed out by Michelle, in the example I gave, in the action against Yahoo US and Yahoo France, the US court, in fact, ruled that the US courts had jurisdiction and that US laws had proper application on the basis of what is known as the passive personality principle. It's a bit controversial, but the US courts ruled in favor of the action against Yahoo France and Yahoo US. Notably, the action would have been lawful in France, but because it offended the feelings of Jews in the US, and there was a law that protected Jews in that regard, then the US court found that the US laws could apply, and that there could be the proper application of US laws. And the passive personality principle actually is often used in relation to copyright laws and intellectual property laws. So imagine if the passive personality principle were not applied. And assuming that there is no treaty protecting intellectual property, and you have, for example, nationals in China, maybe in Thailand, who would then copy, let's say, products of Nike or products of Reebok in the United States, which are U.S. companies, and they come up with imitations of products of U.S. companies. In that case, the U.S. courts have ruled that U.S. laws could reach the nationals of foreign countries or foreign states, because every state has the power and should have the power to be able to protect its own nationals by actions of foreigners abroad. So that's the application of passive personality principle. Now, so going back to the question we have here, as already discussed earlier, it would be it would be unlikely for a court to, so even if Smiths would seek a dismissal of the charges on the ground that the state of Ontario should not have any jurisdiction over him, the Ontarian court would likely dismiss. Rather, would likely uphold the charges against Smiths and deny the grounds for dismissal raised by Smiths on the basis of what is known as the passive personality principle. And as we said, on the basis of the passive personality principle, it is recognized in international law, although it's controversial, it is recognized that a state may pass a law that seeks to protect its own nationals for harm that is caused by foreigners abroad. Okay, so that is according to the passive personality principle. Now, would some of you have come across the concept of the effects doctrine? So there is a doctrine which is related to the territoriality principle. According to the territoriality principle, it is obviously, as part of the territorial sovereignty of a state, it is permissible, a state is empowered to pass a law that governs the conduct of anything that occurs within its own territory. Now, the question is, what happens if, say, there is a foreigner who undertakes certain acts abroad? So there is a foreigner who acts abroad, and the actions of that foreigner harms or has an effect within another state. Would it be permissible for that particular state who is harmed by the actions of a foreigner abroad, done abroad, would it be permissible for that state to exercise jurisdiction over that foreigner? So what happens under the passive personality principle is that the acts occurred abroad and harmed nationals of a state abroad. Okay, here, the question is, what happens if the actions of a foreigner abroad harm the state? So it's no longer the nationals abroad, but harm the nationals of a state. So there are effects, okay, on the nationals of a state. Would a state be able to assert jurisdiction for those actions? So let's say that in the hacking incident, let's assume that the actions of Smiths abroad harm harm the interests of harm the interests of nationals within Ontario itself. So the effects are occurring in the state of Ontario itself. Would, in that particular case, Ontario be able to assert jurisdiction? The answer is yes. according to the effects doctrine, which is related to the territoriality principle. So in this particular case, even if the acts are committed by a foreigner abroad, because the acts of those foreigners have an effect within Ontario, within a state itself, it has effects, then in that case, international law recognizes that a particular state may have jurisdiction. Now, the effects doctrine is different from the passive personality principle because although they have a commonality because in the sense that the actions are committed by a foreigner abroad, in the passive personality principle, the harm is caused to nationals who are abroad. Under the effects doctrine, the harm is done to nationals within the territory itself of the state. Okay, clear? Okay, so let's go to a final question. So the first two questions were questions that I made myself. We're going to examine a question that is in the book of Abbas, who is the author of our prescribed textbook. So discussion question 3. John, a citizen of Kandoma, who lives and works in Rotamu, killed Dan, who is a citizen of Rotamu, when a fight broke out between them over an alleged car theft. So let's go through that slowly because this is a very long factual problem in the book of Abbas. So John, a citizen of Kandoma, who lives and works in Rotamu, killed Dan, a citizen of Rotamu, when a fight broke out between them over an alleged car theft. So that happened in Rotamu, obviously. Now, Rotamu 1 police promptly arrested John and put him in jail pending trial. In connivance with a prison warden, John escaped and fled home to Kandoma. The Kandoman government, headed by John's uncle, decided not to prosecute him. And despite repeated requests from Rotamu to extradite the accused, Kandoma refused. In a spontaneous street demonstration in Rotamu, 5 Kandoman citizens were injured and hospitalized. In a further bid to scare Kandoma and to pressure it into surrendering the culprit, members of the Rotamuan armed forces fired a few shots across the territory, which hit targets in Kandoma, but still, the state of Kandoma refused to extradite its national. After 6 months of waiting in vain, Rotamu sent 10 members of its secret services into Kandoma at night to abduct the culprit. This action angered Kandoma, which decided to commence proceedings before the International Court of Justice, complaining of the violation of its territorial integrity by Rotamu. Advise the parties. What would you advise the parties? What do you think?
So I'm thinking something along the lines of, so when we talk about a state having jurisdiction, we're talking about it being able to make laws that apply to people, enforce the laws that apply to them, and try them for violating those laws. So I think when the other state, you know, more or less broke into that state to enforce laws, then in fact they were completely out of their jurisdiction, and they shouldn't have been in there.
Mm.
Sorry, that wasn't very poetic, but did you get my point?
Yes. So in that case, you were actually saying that Rutamu violated certain norms of international law, particularly the territorial integrity of Rutamu. The territorial integrity of Kandoma, when Rotamuan Secret Service people entered the state of Kandoma in order to effect the arrest of John. That's what you said.
Yep, in a nutshell.
That would be correct. So in this particular case, there is nothing in international law that would actually authorize another state to enter the territory of another state in order to effect an arrest. So assuming that Rutamu actually could have had jurisdiction over John, because obviously John committed a crime in Rutamu. So on the basis of the territoriality principle, Rutamu obviously had jurisdiction over John. Still, Rutamu did not have the power under international law to enter the territory of Kandoma in order to effect an arrest of John. That would violate the territorial integrity of Kandoma. Okay, now that is an interesting point, because you may have come across the news story sometime last year, I think, where there were some Israeli, how do you call them, spies, assassins, who were caught on video, CCTV, closed circuit television, as being kind of responsible for assassinating somebody in France. Now, going back a bit to the Berlin Olympics, if some of you will remember that, it was called the September incident. I think it involved the Black Panthers. So there was a terrorist group that kidnapped, not really kidnapped, but they entered during the Berlin Olympics. They ended up rounding up certain Australian athletes, Olympic athletes, who joined the Berlin Olympics, the Olympics in Berlin, sometime in 1966. And it was called the Black September incident. And what happened was that they ended up killing a number of Israeli Olympians, but they were able to get away. They escaped. And what makes this interesting is that what the Israeli government then did is that through its spies, they actually ended up looking for those Black September terrorists who were responsible for killing the Israeli Olympians, and they killed most of them. And I like that incident particularly because there is an Israeli author who is now an American. I'm trying to think of his name, but he has a character called Gabriel Alon, and I love his novel. Daniel Silva is the name of the American author who is Israeli and Jewish of origin, and he talks about this very diminutive spy called Gabriel Alon, who is actually an art restorer. But Gabriel Alon happens to be a spy who goes around various states to look for terrorists, and he kills them. And I like the story a lot. And so the Israeli government was accused of by France last year, I think, or 2 years ago, of sending a team of assassins into France for the purpose of assassinating a known terrorist. The question is, would it have been within the power of France to file a complaint against Israel for violating its territorial integrity? If it had gone to the International Court of Justice, it did not. But if it had, how would the International Court of Justice have ruled on it? On a claim that there was a violation of territorial integrity of France by Israel by sending its team of assassins into France?
Sorry, it was convoluted facts, but I think yes, France could say that they've violated their territory.
That would have been the way that the ICJ would have ruled on it. Now, what's interesting is that if you go back a bit, I think in the 1990s, have you heard of the name Manuel Noriega? So Manuel Noriega was the former dictator, president of Panama. And he was known for committing human rights violations and abuses within Panama. And what happened was that I think sometime in 1989 or in the early 1990s, I think it was 1989, the United States sent, because the United States has a military base in Panama. From its base in Panama, they sent a team of military officers and soldiers inside Panama, outside of the U.S. military base in Panama, in order to arrest Manuel Noriega. Okay? And they actually arrested Manuel Noriega, who at that time was the lawful president of Panama. And they arrested Manuel Noriega and brought him to the United States. Okay? Now, the question is, one, could the U.S. assert jurisdiction over Manuel Noriega? And if so, on what jurisdictional principle? And could Panama have complained to the ICJ that the actions of the United States were in breach of its territorial integrity? Two questions. What do you think? So question one, on what jurisdictional principle could the U.S. assert jurisdiction over Manuel Noriega? And secondly, whether or not if the state of Panama had filed a complaint with the ICJ on the ground that the United States violated its territorial sovereignty, how would the ICJ have ruled on that complaint? Question one, what do you think? Jurisdictional principle first.
So I think it would come under universality.
Yes, go on.
Considering the peremptory norm.
Mm-hmm.
I think the ICJ would say, again, considering the peremptory norm, that it did indeed have jurisdiction and was well within its rights to move forward with that.
Very good. So let's stop there, Megan. So that's right. So on the basis of a claim of under the universality principle, the United States was able to make an assertion that Manuel Noriega was committing crimes against humanity, or was even committing genocide for certain human rights violations within Panama. So even if those actions did not affect U.S. citizens or U.S. nationals, and even though those actions were affected by a non-national, such as Noriega, within Panama itself, on the basis of what are known as nationality principles, a state can assert jurisdiction still over a non-national who commits acts of genocide or crimes against humanity abroad. So that is the application of the universality principle. Okay, and that can apply, for example, to the actions of Rodrigo Duterte, the president of the Philippines, who has caused the murder of about 5,000 Filipinos so far within the Philippines. Imagine that. So it's a scary, very, very scary country right now. And the question is, if assuming it's not the International Criminal Court of Justice in the first place, but assuming that there is a law passed by the United States, which would make it unlawful for somebody like Duterte to commit wide-scale killings of its own citizens, what would be the jurisdictional principle that could be the basis for the exercise of jurisdiction? It would be the principle of universality, because it could be alleged that Duterte has committed crimes against humanity or crimes of genocide. Okay. Now, I had a second question, and the second question was, what if Panama complained to the International Court of Justice saying that the United States violated its territorial integrity? What do you think would the ICJ say?
Would they say that they did breach the territorial aspect, but because of the universality principle, it's acceptable?
Okay, so let's ask that question. Would it be acceptable would it be lawful for a state, on assuming that it in fact has jurisdiction, would it be lawful for a state to enter the territory of another state in order to exercise jurisdiction over a person? The answer is no. That would still be a violation of the territorial integrity, of the territorial sovereignty of another state. Now, so going back to that question, assuming that Panama, so in fact, Panama did not file a complaint against the US simply because the president who then took over was somebody who was beholden to the United States. Okay, so Panama did not file a complaint, although it could have. But even if it did, there would have been a problem about the ICJ exercising jurisdiction over the US. Because the only way for and this goes back to the issue of consent, the only way for the ICJ to assert jurisdiction or exercise jurisdiction over the US would have been if the United States would have consented to the exercise of jurisdiction by the ICJ. And the US would have refused the exercise of jurisdiction by the ICJ. Okay, questions, comments? Before we end tonight's session.
What you were just saying there, Manjo, just makes me wonder how the ICJ can have any effect at all in cases like Duterte. Like, really, how can they stop him if they can't go in and you know, does it take one state to make a stand? And
that's right.
I don't know, it just seems ridiculous, like they have no power at all.
There is, in fact, the international law can kick in because it's not going to be on the basis of the ICJ statute. There is what is known as the Rome Statute, which is the multilateral treaty signed by many states, not the US though, but one of the signatories is the Philippines. And under the Rome Statute, which created the International Criminal Court of Justice, so there is an International Criminal Court of Justice, the International Criminal Court of Justice has jurisdiction over crimes of genocide, crimes against humanity, including war crimes. So Duterte apparently has committed crimes against humanity, which is defined in the Rome Statute as the systematic killing of persons. So there is clear evidence of Duterte committing crimes against humanity or even crimes against genocide, which is a crime as defined under the Rome Statute, which is a multilateral treaty of which the Philippines is a signatory. And because the Philippines is a signatory, the Philippines therefore has an obligation to comply with the Rome Statute, and it therefore has given jurisdiction to the International Criminal Court of Justice to exercise, to assert its authority over Duterte. So, but the International Criminal Court of Justice obviously cannot go to the Philippines to effect the arrest. But if Duterte somehow were to go to the US at some point, and there were now criminal proceedings that were initiated in the International Criminal Court of Justice, Duterte could find himself in prison. And that is the way that has happened with, during the Bosnian war crimes, where Milosevic was actually arrested and imprisoned and has in fact been sentenced for violations of crimes against humanity and also against war crimes. So that is on the basis of the International Criminal Court of Justice, which is a different international court. And the basis for that would be the Rome Statute, which created the International Criminal Court of Justice and which has as signatories several nation states, including the United States and Australia, but not the United States. So the International Criminal Court of Justice cannot exercise jurisdiction over US officials because the United States is not a party to the Rome Statute. Okay, questions, comments? None?
Can I ask a question?
Yes.
So, assuming Dante or whatever his name is, then travel to America,
Yes.
it means ICJ cannot still exercise jurisdiction because, or will ICJ be able to exercise jurisdiction over him, knowing that US is not a signatory to the Rome Convention?
That's a very good point. That's a very good point, Yomi. That's right. Yeah, so but we're talking of the International Criminal Court of Justice here. Okay, so the question would have been, could the International Criminal Court of Justice ask the United States to effect the arrest of Duterte if Duterte went to the US on the ground that Duterte is in breach of the Rome Statute? That's a good point.
Yes.
Probably not. The United States might not necessarily comply with an order, but nothing would stop the US government from arresting Duterte in the first place on the ground that Duterte has committed crimes against humanity or acts of genocide. So if the United States were to effect the arrest of Duterte, that arrest would not be effected on the basis of his obligations under the Rome Statute, but on the basis of peremptory or jus cogens norms. So what we remember is that states have a universal obligation for certain peremptory norms of international law or jus cogens norms, whereby certain acts such as piracy, slavery, human trafficking, and genocide and war crimes and acts against humanity are violations of international law. So therefore, the United States might assert that on the basis of the fact that Duterte has committed violations of jus cogens norms, it is going to effect the arrest of Duterte and bring him over to the International Criminal Court of Justice, not on the basis of its obligations under the Rome Statute, because it has none, but because it is complying, because the United States is complying with its obligations to ensure that jus cogens norms are observed and not violated by states or its officers. That's a very good question. Okay, any other questions or comments before we end tonight's tutorial? None? Okay, so thank you again, Megan, Michelle, Yomi, and Peter for being at tonight's session and for engaging actively at tonight's tutorial. It would have been quite uncomfortable if for all of us if you didn't really engage, but you did. So thank you very much, and I look forward to seeing you again next week. Good night. Bye.